Okay, welcome to the General District Court Clerk, Traffic Division Part 1. I'm your host, Kevin Lacey, Virginia Attorney and Certified Court Manager. In this session, we'll be walking through some of the procedures that a Deputy Court Clerk would have to go through when working in Traffic Division. Alright, first we'll start out with the case types in Traffic Division. You're going to have your basic traffic infractions, which are administrative non-criminal violations. However, you would also be dealing with certain criminal offenses that fall under Title 46.2 of the Code of Virginia. That would include a no driver's license, driving on suspended license, reckless driving, or DUI. These are all criminal offenses that carry potential jail time, even though they are misdemeanors. Okay, we'll start off with case initiation. Any criminal or traffic case is going to be initiated either with a police summons, a magistrate summons, or a magistrate's warrant. A summons, whether issued by police or magistrate, requires an individual to appear in court for trial. Warrant, on the other hand, authorizes the police to arrest the individual and bring them before the magistrate for a bail hearing. And then when the defendant's released on bail, they have to appear for trial. What you're looking at, this is real quick, that's just a magistrate summons. Of the police summons is a similar looking form that would be issued to initiate a case. Alright, next we're just going to look at the pretrial processing procedures for the clerk. The clerk is going to assign a sequential number to the case on the summons or warrant. Then I'll enter all the information into the case automated system, which is known as the case management system. Then file the case by court date and staple any license that was seized by the police to the paperwork. This is called an administrative suspension of license, and that happens in DUI cases. And then the clerk's going to issue a subpoena for witness if one was requested. Alright, and this is briefly the prepayment information sheet. Generally, the clerk is not going to issue the requested subpoena unless the defendant brings back this prepayment information sheet to the clerk's office and explains they're intending to go to trial and not prepay the offense. The reason why is we don't want to be subpoenaing witnesses, bringing them into court, and confusing them when the defendant is just going to prepay the offense and there's not even a need for a trial. Real quick, going into docket preparation, which happens on the day of the case. In this case, the clerk is going to retrieve all the cases from the files for a given court date, arrange the cases in the order preferred by the court, print the docket via CMS, the case management system, and add additional cases to the docket as they come into the clerk's office, and then distribute and post those copies. Clerks also need to properly store certificates of analysis of the blood sample, which are commonly used in DUI cases to determine blood alcohol content. Okay, next we'll go through prepayment procedures. The Supreme Court has to designate by rule which infractions can be prepaid as well as which criminal offenses can be prepaid. And the Supreme Court of Virginia has come out with a uniform schedule of prepayments and what the fines and costs would be. After that, the clerk needs to determine the proper jurisdiction for the case and determine whether the defendant is an adult or juvenile. Juveniles can only prepay in very limited circumstances. Okay, next we want to ascertain if the case has already been tried. If it's already been tried and there's been a final disposition, then there's no need for a prepayment. So we want to verify that. Then the defendant fills out the waiver of trial form on the summons for the traffic offense. And let's see now, you can also use the District Court Form DC 324 if they don't have that summons with them. And let's see now. That pretty much covers all that. You want to inform the defendant of the right to pay by cash or credit card. And people also need to be informed that if they choose to prepay by mail, that the prepayment is only effective on the day that the mail is received by the clerk's office, not the mailing date. Um, if you're dealing with the defendant in person, you need to determine the actual fines and costs using the uniform fine schedule. Then take the payment and print the receipt. Alright, so next we're going to cover what happens when someone makes an overpayment. That is, they give you more money than they're supposed to when they make a prepayment. In this case, when it's in person, a refund by the court check is permitted when the overpayment was made by certified check or money order. However, with a personal check, if the defendant paid with a personal check for the prepayment, an immediate refund is not permitted. Refund may be sent only after the defendant's personal check clears the bank. However, the defendant should be required to write a check for the correct amount. Third-party checks should not be accepted. Okay, so what happens when there's an underpayment in person, i.e. they don't give you enough money to satisfy the fines and court costs? Well, first of all, partial prepayment should never be accepted. Instead, the defendant should be requested to mail or deliver the proper amount together with the signed guilty plea and waiver of trial before the cutoff date for accepting prepayments. And we want to make sure that credit card and debit card payments are only made for the correct fines and costs. Alright. There also are online prepayments by something called VIPNet, and they can be used for certain traffic offenses on the court's website at courts.state.va.us. Payments are accepted until 3:30 p.m. on the last business day before the court date. Please note, pre-court payments are deemed a waiver of a court hearing and entry of a guilty plea, just like any other prepayment. Alright, so what if before the trial date the defendant who's already prepaid wants to withdraw the guilty plea and go to trial? Can he do it? The answer is yes. However, the defendant is required to provide the court with a written statement withdrawing the guilty plea, and as the clerk of the court, you're going to refund the fines and costs. However, hold the refunds on personal checks until the check clears, and you also need to inform the defendant of his next court appearance date. Okay, next in our courtroom clerk duties. The case disposition. If a prepayment is made, then the disposition section should be marked to show that the case was handled as a prepayment with a guilty plea and finding of guilt. Alright, in the event that the defendant doesn't prepay, then we're going to trial. When the defendant shows up in court, he can plead guilty, not guilty, or no contest, which simply means I'm not admitting to guilt, but I admit that the prosecution or the police officer has enough evidence to prove beyond a reasonable doubt that I'm guilty. Defendants can be tried in their absence if they don't show up, and that's only if a jail sentence either cannot be imposed or will not be imposed. Remember, only Class 1 and 2 misdemeanors carry jail time, and felonies are going to be taken care of by the criminal division. Alright, next we're going to briefly talk about ensuring adequate notice of a suspension of license. Usually when a defendant's convicted of certain criminal offenses under 46.2 or in the event of repeated traffic offenses or a failure to pay fines and costs for traffic infractions, their license is going to be suspended. In this case, if the defendant's in court, they're going to have to fill out the DC 210 Acknowledgement of License Suspension or Revocation. If they're not in court when this occurs, such as if they failed to pay fines and costs, then the clerk's office is going to need to mail out that form. Now we're going to go into the post-trial payment procedures. For those convicted of traffic offenses who wish to pay the fines and costs within 30 days, it's very similar procedure to the prepayment procedure. The clerk's office is going to determine the amount of the fines and costs from the case papers, then collect those fines and costs, and then prepare and issue a receipt. The clerk would also then deposit the money in a bank account for the court. In addition, there's also deferred or installment plans, deferred payment or installment plans that the court has the power to set up if the defendant claims they're unable to pay. However, in the event that final payment still hasn't come according to the installed plan, then the district court form DC 225 notice to pay and notice of suspension for failure to pay will be mailed out to the defendant, and the clerk's office is going to need to do that. Just a few final duties. Clerks are going to use the CMS DMV interface to notify DMV of any traffic convictions. Obviously, that's real important because that's going to affect whether someone is able to keep their license. Also, the clerks are going to need to update the CMS with the final case disposition and make sure that the judge records the final disposition on the back of the summons or warrant. So just remember, we have that two-tier system: the paper system with the summons or warrant, and then CMS. All right, that's going to be it, folks. Hope you enjoyed the presentation.